morning. Everybody hear me okay? That is loud. Okay, I'll use my inside voice. Welcome to the October docket of the Court of Criminal Appeals sitting here in Knoxville on the campus of Lincoln Memorial Law School. We are so pleased to be here with you today and see so many students here. Let me introduce our panel, and then I've got some folks that I want to thank for helping set all of this up, and then we'll talk about our process today. So to my right is Judge Tom Greenholz. He comes to us from Hamilton County in Chattanooga, and to my left is Judge Kyle Hickson from here in Knoxville, and I am Judge Jill Barty-Ayers from Clarksville, Montgomery County, Tennessee. I sit in the middle section. So we are also pleased to be here today. I want to really thank the LMU administration. It was about a year ago, Judge Greenholz and Judge Hickson and I, actually the three of us sat on the campus of UTC, and Judge Greenholz looked at the calendar and said, let's do this again next year. We're in the East, let's go to LMU. So he has been taking the charge on this and setting it up, and I want to thank him and his staff, Addie Nestor, and I think Brianna Williams from Judge Hickson's office has been really helpful for that too. But thanks to the LMU administration for being welcoming and agreeable to set this up. Dean Matt Lyon and Dean McRae, we appreciate you all. Our clerk's office from Knoxville, Francesca Kraft, is here with us today. She keeps us always on track, and so we appreciate her and her staff. And we couldn't do any of this without the administrative office of the courts, and Nick Morgan and his staff are, I think, testing out some new technology on this today. In case you don't know, all of the appellate arguments, Court of Appeals, Court of Criminal Appeals, and the Supreme Court are always live streamed. So if you have curiosity about just what that looks like or any particular case, you can watch them live, and they're also all archived. You can go and watch later. But they're great at putting that together, so we appreciate them. Also, to make this happen, the attorneys who participate in these cases have to be agreeable to come here, so we are very grateful for you all, for your willingness to come off-site and also to argue in front of a much larger crowd than we are used to, so that make it a little more exciting. And then last, thank you to the students who've taken time to come here, and professors who may have let them out of class or made some alterations. We appreciate y'all being here. This is one of the most fun things, I think, if you ask any of us, that we all enjoy doing, is kind of bringing the courts to you. I think the lawyers would agree with that as well. I don't remember having this opportunity when I was in law school, so we try to make that available, and thank you for taking advantage of the opportunity. Okay, so how we operate, we're doing things a little bit differently today. Around the schedules, we've got a case at 10, another at 11, and then another at 1:30 after lunch. Each side has 20 minutes to argue, and it looks like we do have our timer. Thank you for bringing that over. If the appellant wants to reserve any time, let us know. And then normally we just run through all of our cases, taking breaks as needed, but today we're going to break after each case, and we're actually going to leave and give the students the opportunity to ask questions of the lawyers. Because if we stay in here, you can't talk about the case, and I think that's usually what's most interesting to you all. You want to ask questions about strategy and maybe some of the facts that didn't come out at the argument. So we're going to do that. So y'all have that opportunity, and then we are going to be available at lunch to talk with and meet with students as well. Did I miss anything?
Excellent.
Anything
yes.
you want to add?
Thank you all for allowing us to be here today. It is a real privilege for the court actually to come in and spend some time with you all today. We get much more out of this probably than you do, and so it's just wonderful to be here. Also, Judge Ayers mentioned it, but thank you very much to the lawyers who put this on. We couldn't do it without you, so thank you all very much.
Yeah, thank you guys. The hospitality's been wonderful. I was just telling Dean Lyon, this room is just beautiful. I especially enjoy the portraits of President Lincoln. Those are beautiful. Just what a great setting to see legal practice like this take place. And as a Knoxvillian, this is definitely something for us to be proud of. So thank you guys.
Great. Any preliminary matters?
No, Your Honor.
All right, if you'll call the first case, please.
Ricky Davis versus State of Tennessee.
Good morning, Your Honor. It's Joshua Hedrick for the appellant Ricky Davis. I'd like to reserve 2 minutes of my time for rebuttal argument. May it please the court, Ricky Davis is entitled to post-conviction relief in this case for 3 reasons. First, that it was ineffective assistance of counsel to let the jury hear that Mr. Davis had a prior conviction for causing bodily injury with a deadly weapon in his homicide trial. And second, that it was ineffective assistance of counsel for trial counsel to fail to challenge the admissibility of the prior gun possession. And third, that it was ineffective assistance of counsel to fail to object to the key witness's prior statement essentially being read into the record when there was no basis for that under our rules of evidence. So I'd like to begin with the prior conviction. So in this case, Mr. Davis was charged with killing another man. It was a murder charge. And in the same indictment, he was also charged with the weapons offense that included the allegation that he had a previous crime of violence, which is a necessary element of that offense. And when that happens, it creates a difficulty that this court has wrestled with, I want to say at least several times. What do we do when we have an indictment that properly asserts the elements of the offense, but in doing so creates a prejudicial impact from one offense to the other offense, right? So in this case, we had a gentleman who is accused of first-degree murder, and the indictment alleges that he had previously caused bodily injury to another individual while using a deadly weapon. Now, standing alone, that would create a significant 404B problem. That is, if we forget the weapon charge and just assume that you have a man on trial for murder, and the state wants to talk about sometime in the past where he committed an aggravated assault on someone with a deadly weapon, most trial judges would say, I need more than that. I need some justification for the jury to hear this under 404B. And so this court in 2015 in State v. Faust observed that, and I'll quote, we note the better procedure where, as here, the defendant is charged with offenses involving the use of violence and force, and also charged with the status offense of unlawful possession of a firearm for having similar prior felony convictions would be to bifurcate the proceedings and address the unlawful possession of a firearm charge separately. Essentially, not a full-on severance, but separate those offenses so that the jury deciding the homicide count does not yet know about this prior offense and can make the determination on the homicide count without that prejudicial information.
So Faust didn't set up a requirement to bifurcate though, is that right?
Faust does not set up a legal requirement. I want to push back on the way you use requirement.
Has any decision from this court required bifurcation?
No, there is no decision that requires a court to bifurcate. There is the observation that this is the better practice, and of course, I would suggest that a court that doesn't runs the risk of being said to have acted in error. But I want to.
Do we have cases though where we have reversed and remanded for a new trial where there was not a bifurcation?
Not that I can find, Your Honor. Although I want to separate the requirement, as in the precedential requirement of what a court must do, from the requirement of effective assistance of counsel, which are not always the same thing. There are many times when meeting your obligation as effective defense counsel isn't a question of meeting a legal requirement or not, but performing adequately to your client. And so in this case, the only reason I would posit to the court, the only reason that this jury heard about this prior in this homicide case is because trial counsel did not raise the issue. And the only justification trial counsel offered for that was that trial counsel was unaware of this case, even though it predated this trial by several years. And so it may not appear in the record, but when we look at Faust, And then we look at Richardson. We essentially have, when we think about Richardson and Faust, we essentially have two solutions to the problem. And I don't know that I can cite to the record for this, but the trial courts take this seriously, even though it is, I think what I quoted from Faust is probably appropriately termed as dictum. That is, it is not a holding. It is not the rule in Faust is you must bifurcate. But trial courts pay very close attention to what this court says, because trial courts want very much to do right and will take that as a best practice. I also want to point out that when we're talking about someone who is on trial for life, because this is a first-degree murder case, it is incumbent upon all parties involved to employ the best practices. That if this court has observed in Faust the best practice is to do X, I say that the trial court should take heed and should follow the best practice.
But that's not what the Sixth Amendment requires, right? I mean, so we're looking at this through the lens of the Sixth Amendment, which guarantees the effective assistance of counsel.
Yes.
And so the allegation here is that counsel did not provide effective assistance. The Sixth Amendment doesn't require best efforts. The Sixth Amendment doesn't require best practices. The Sixth Amendment requires only the bare minimum that a competent lawyer would give. And so in this case, as I understand the argument, we have a lot of discussion about the deficiency of counsel, but in the brief I didn't see where we're talking about prejudice. Because when we're viewing the case through the lens of the Sixth Amendment, not only do we have to show that counsel acted deficiently, but that deficiency undermined confidence in the verdict. Phrased another way, sometimes you see in our cases that it would have led to a different result at trial. So it could have been a conviction on a lesser included offense, it could have been an acquittal perhaps. I don't see any discussion of the prejudice aspect in the brief.
So in this case,
Has that argument been waived?
It is not waived. It is for the court to determine. I think that issue is raised. The difficulty in arguing prejudice frequently is that it is difficult to phrase as a but for. It is difficult to prove, I should say. I should say difficult to prove as a but for.
It's intended to be a difficult to prove standard, I think. Whether I agree with that or not,
Sure.
I think it's intended to be. So how do we have that here, though?
And I can't say to the court that I can point to a part of the record and say, you see here, this is where the jury locked onto this and made their decision based on this, because we don't know that, and we can't know that, right? But what we can know is that this is a case where the trial attorney has no strategy behind this failure to act. And so the question, if we phrase prejudice as calls into question the fairness of the result, calls into question the confidence in the verdict, right? Undermines our confidence in the verdict, undermines undermines our confidence in the fairness of the process. We have an individual who, for no reason, had prejudicial and extraneous information presented to the jury. For no reason, for no strategic reason.
Wasn't there information in the record that I guess came from trial counsel
Mm-hmm.
that post-conviction court credited that the defendant would not stipulate to the underlying felony, and therefore there was no other way to get that in?
So there is.
What do we do with that?
Your Honor is correct that of the two options, Richardson appears to be off the table, right? That we have crafted in the law two avenues: either the stipulation through Richardson, where the parties stipulate that this is an appropriate charge, however you phrase that stipulation, or bifurcate the proceedings. The inability to take advantage of one avenue doesn't excuse ignoring the other, right? Saying that he will not stipulate, that's fine. That doesn't impact, respectfully, that doesn't have anything to do with whether trial counsel should have said, Your Honor, we need to bifurcate this. Your Honor, I object to the jury being told that he has a prior violent felony against another person, And frankly, it is in a way shocking that trial counsel would not have identified this as something to object to. The trial counsel would not have come to the court and said, I want to argue to you to keep this out, especially since there is a reported case that says this is the best practice. Respectfully, if I read a Court of Appeals opinion that said this is the best practice, you can be certain that I would make every effort to put that into practice in my defense of my clients. And I would tell the trial court, I object, and the reason I'm objecting is because the Court of Appeals has said, in dicta, but has said this is a problem, and it needs to be addressed, and this is a good way to address it. And
Well,
Judge,
I mean, but with respect, though, I mean, and you and I have had some good history on the trial court bench. I think you're an effective advocate. I think you're an outstanding trial lawyer. It doesn't surprise me that you wouldn't adhere to the best practice. That's not what the Sixth Amendment requires. The Sixth Amendment doesn't require your representation.
so it does not require perfect representation. But
Minimally
when we
competent
read
representation.
when we read Strickland, a lot of the deference in Strickland goes to strategic deference, right?
It does.
And there's a lot of deference to when we talk about it. When we talk about the idea of representation must not be perfect, there's a lot of case law that suggests that we give leeway to strategic decisions that failed, right? That we don't require counsel to be perfect. It's okay if you make a reasoned strategic decision and it doesn't work. You were imperfect, but you were not ineffective. And I think in my argument I'm trying to draw the distinction between the reasoned strategic decision that doesn't work and simply being unaware of the problem. Because the record here indicates that trial counsel appears to have been totally unaware of the problem. And that, respectfully, is too far to the other direction to say that Mr. Davis received a fair trial. To say that we can have confidence in the verdict that was received. Because the jury it is very difficult to ignore, just as a matter of human nature, in a homicide case. And the proof in this case was all right, but not damning. So it is very difficult in a case to imagine a jury ignoring being told, he also took a deadly weapon to somebody else and hurt that guy pretty bad, serious bodily injury. This is the second time he's taken a deadly weapon to somebody. This
Were the
time he killed
details of the previous crime given to the jury?
The details were not, but
It was just the nature of the offense, right?
the nature of the offense, and in listing the nature of the offense, the trial clerk was called as a witness and was asked to testify and testified that this was an offense involving serious bodily injury and involving the use of a weapon to cause serious bodily injury, which would be appropriate which would be appropriate if it were a trial just on the weapons charge, because those are necessary elements to establish whether we're a Class B or some other class. But you have now told the jury that I'm alleging he killed this guy with a gun. And before he did that, he also seriously bodily injured some other guy with a deadly weapon. Those are not the right words, but
You may have coined a new phrase.
Yeah.
well, there you go. Well, at least that's my 15 minutes. So it is very difficult to ignore that impact. While on the subject of the gun,
Well, help me with this real quick, though.
I
Mr.
really
Everett.
thought you were going to let me off of this.
No, that's not how we operate. So what do you make then, and I fully take the point here, that it's a strategic call, generally speaking. We defer to matters of strategy. There may not have been a strategy here. And so we have superficially deficient performance, arguably. What do you make of the fact that the trial court said that had it been presented with a motion to bifurcate, that it would have denied the motion? At that point, I think whether the trial counsel decided knew about Faust, didn't know about Faust, move to bifurcate, not bifurcate, at that point, it truly is no harm, no foul as far as trial counsel's concerned, because it seems that you have a finding that the motion wouldn't have been granted. And it wasn't required to be granted under Faust or any of our other cases. And of course, the trial court's not obliged to put pressure on the accused to
To
stipulate.
enter a stipulation, right.
Which is, I think, is what Buchanan says at the state sides. So with that finding in the record, how do we even get to deficient performance, even setting aside prejudice?
I will tell the court that I think that finding creates, in fairness, I will tell the court I think that finding creates a prejudice problem. However, I think the court must then analyze whether that ruling would have survived appellate review under these circumstances.
And that would have depended upon appellate counsel raising the issue.
Which would have depended upon, right, so, and sort of by that.
There's not a claim against appellate counsel in this case.
Well, because appellate counsel was not ineffective unless it was raised.
Didn't raise it on plain error.
Didn't raise it on plain, that's correct, didn't raise it on plain error. So when we have that finding by the trial court, then the question is, one of my concerns about the finding by the trial court is it is an unusual finding given that the trial court cannot analyze an argument it hasn't received pre-trial. The trial court is looking back at this argument, but we don't know what the trial court would have done. We don't know exactly what the trial court would have done pre-trial because
Was it a matter of practice in Knox County at the time, though?
it was.
So
And I can't say that
we might know, right?
Well, I can't say that it appears in the record, but Judge Green in Division 3, I will tell the court, does not hear motions regarding bifurcation. He will simply say, this indictment has a homicide and a gun charge. Which one do you want to try first, General? And with the district attorney will choose one, and he'll say, all right, well, we're splitting it up. We're going to try this one, and we'll try. He will conduct separate trials. I can tell the court as an officer of the court that I've had that happen in my cases without me filing a motion, that we have just been on to set a trial date, and he has said, I'm setting the homicide and I'm setting the weapons charge here because we're not doing them together. And he'll say, if I try them together, I'm going to get reversed, and I don't want to get reversed.
Am I correct, Mr. Hedrick, that the post-conviction court did not hear this case at the trial level?
I can't, I'd have to look at the record
It was,
to know, Judge.
belief-
I don't know that offhand, I'm sorry.
I want to say that Judge McGee tried this case in Division 2 court.
Judge Sword did the post-trial motions.
Post-conviction.
And so, you're right, actually, now that I look at it, Judge McGee tried the
So
trial.
isn't that another layer of speculation as to what the trial court would have done?
I agree with that,
presenting
and
this issue?
I cannot offer any guidance as to what Judge McGee would have done. I mean, I want to be really clear. I don't want to be misleading. My discussions about Judge Green, that's a third other judge that doesn't really inform us about Judge McGee or Judge Sword.
Well, but maybe on the other hand, going back to Judge Hickson's point, I mean, the burden is on the petitioner in a post-conviction case
That's right.
to prove the facts by clear and convincing evidence. And so it's not really speculation necessarily, it's just the fact's not in the record. And the petitioner just hasn't shown that had a motion to bifurcate been made, it would have been granted.
However, respectfully, if I see that I'm out of time, if I may, respectfully, that's not something that a petitioner could ever prove. Because the only way to do that would be to present Judge McGee to testify about what Judge McGee would have done. And I see your eyebrows. Perhaps we should have done. But I'm not.
I mean,
I would
the
not
burden
have.
is on the petitioner.
I would not have considered calling a trial judge to testify. I would not have considered calling a trial judge to testify about what the trial judge would have ruled had a motion been made. And I have concern about the precedent that would create
I would just like to have seen the response.
Well, if the
I was
court.
thinking the same thing.
If the
When he
court
got
had-
that subpoena from
I'm
Mr.
concerned about what that holding in this case would do precedentially to tell post-conviction petitioners we need to start putting trial judges on the stand to ask them
maybe it's just more
hypotheticals.
simple than that. Maybe it's just, no matter how you do it, the burden is on the petitioner to show that had an objection been made and a request to bifurcate been offered to the court, it would have been granted, no matter how you prove it. I mean, without that, there seems to be a conceptual
difficulty.
void maybe in the deficiency problem.
And that may be, I cannot point to a place in the record where I overcome that issue, Your Honor. Yes.
Thank you. Jenna?
Morning. May it please the court, Catherine Redding on behalf of the state. Petitioner has not shown that trial counsel was ineffective for allowing the jury to hear about his prior conviction. Petitioner has not shown that counsel was deficient in this respect. He hasn't shown counsel was deficient for failing to offer a stipulation because, frankly, the record shows that the petitioner refused to stipulate. And counsel's ability to offer a stipulation depended entirely on the petitioner's participation. The counsel could not offer a stipulation without the petitioner agreeing. So that avenue, really, the petitioner didn't agree to a stipulation, so counsel cannot be found deficient for failing to do something counsel's hands were tied against.
What about the bifurcation?
Sure. Counsel could have moved for a bifurcation, and it's the state's position that her failure to do so didn't cause her representation to fall below the range of competence. As Judge Greenholz, if you pointed out, petitioners are not entitled to perfect representation. They're not even really entitled to great representation. They're entitled to kind of a spare. There's a floor, not a ceiling. So we are talking about like whether counsel's representation fell below the standard of a standard for a competent attorney in a criminal case.
Is that the state's position, though, that a competent defense attorney in the state of Tennessee trying a case in Knox County where I think it's clear from the record this has been a repeated issue on multiple cases, doesn't know the state of the law? Faust, it's not some obscure
No.
case. It's a reported case. It's precedential law in the state of Tennessee.
Yes.
Is that really the state's position, that a competent attorney doesn't need to know those types of things before they represent someone in a first-degree murder case?
I think that what makes the difference is what Faust actually says, because Faust does not say attorneys are required to move for bifurcation. Faust says bifurcation is preferred. Faust also doesn't put out a procedure for bifurcation. So certainly counsel should have been aware of this decision. It was published, but when you—
There's a whole long line of cases since Faust, citing back to Faust, reiterating that is the way to do it.
Yes, and I believe the Supreme Court has actually weighed in on this, and possibly just in a footnote, but there still is not a the Supreme Court has agreed that bifurcation is the preferred method. There still is no procedure for doing that.
Doesn't Rule 14 cover severance of charges? Whether it's bifurcated or whether it's severance, doesn't that give an option to get this out of the first-degree murder trial?
Yes, and I will say, I think it's the same case in the name. Maybe it's the Curry case, but I believe perhaps it's not Curry, but there is a case that distinguishes between severance and bifurcation. And so as to bifurcation, Faust is binding. Counsel certainly should have known about it, but if you couple the holding in Faust and the direction in Faust that bifurcation is preferred but not required, and then you take the standard practice in Knox County, which we have from the post-conviction court saying that at the time the practice was to accept stipulations but not go with a bifurcation. So if you couple kind of the non-requirement but guidance with the local practice, I don't think that you can reach the point of finding that this attorney was deficient for failing to move for bifurcation. The lack of knowledge of Faust on its own does not rise to the level of causing counsel to be deficient.
How do you address the speculative nature about what the trial court would have done or not done? So Judge Hickson says, I think perhaps rightfully so, we had a different trial judge. Trial judge was not offered at the post-conviction hearing. We don't really know what would have happened with Judge McGee had the motion been made. What's the response to that?
Well, I think, again, it's, as the court has noted, it is a petitioner's burden, but I'd actually point to some findings that the post-conviction court made which tie into the severance issue. So trial counsel did actually file a motion pre-trial to exclude the prior convictions, and that was denied, obviously, for this particular charge because it's an essential element of unlawful possession. But the post-conviction court it does not appear that the court just drew out of thin air this finding that the trial court would have denied a motion for bifurcation. When it looked back at the hearing on the motion in limine to exclude the prior conviction, And it seemed to have based its conclusion that counsel would not have been successful in moving for bifurcation on the trial court's comments in the context of the motion in limine. But I think that even if this court were to find, well, it's too much. That's too much speculation. And the bigger issue is prejudice. And Judge Greenholz, I would agree with you that it does not appear that the petitioner has raised prejudice, or at least offered sufficient argument on this point in his brief. And so this court is well within bounds to find that the prejudice claim is waived, and because Strickland requires both deficiency and prejudice, to find that the petitioner's...
Is prejudice obvious here? I mean, I think your friend on the other side, I didn't take him to argue this specifically, but it is, I think, the natural conclusion of the argument that it's obvious. That here, when we're talking about a first-degree murder involving a weapon, and you tell the jury, this isn't his first time. He's done this before. Isn't that prejudice obvious? I mean, that's the whole reason we would keep it out under Rule 404B, perhaps, in circumstances. A whole lot of reasons why we wouldn't introduce it to the jury, because it's inherently prejudicial.
I think that, I don't think that the prejudice is obvious. I think that when we look back at Strickland, at the standard, you have to show a reasonable probability that the trial outcome would have been different, or...
That's the outcome of the trial.
Yes.
Right.
Or it kind of a little bit of a different lens, that it undermines confidence in the verdict. And so that requires us to look not only at, this information that the jury heard, and the record will speak more accurately to this, but my recollection is that the court clerk testified that he had a prior for aggravated assault with a deadly weapon. I'll say I did not brief this case, and my recollection of the record on this, the details of how detailed the clerk's testimony was about the underlying facts, I'll rely on the record for that point. But when you go back to the Strickland standard, you have to look at this information. Yes, it was presented to the jury, but what else did the jury hear? And in order to find, the petitioner can't show a reasonable probability that the trial outcome would have been different, because the jury just did not convict him of first-degree murder based on the fact that he has a prior for aggravated assault with a deadly weapon. What they convicted him on was his statements to Ms. McDowell, his statements to Mr. Dobbins, where he admitted shooting the victim. He provided details to Mr. Dobbins about, well, I shot him once, it didn't, and then I shot him again, and I finally got him. He made statements to Ms. McDowell about, well, he owed me money, I believe there was some sort of debt, and I shot him, I killed him. And then we have phone records and Facebook, which paired together show that the defendant petitioner was essentially threatening the victim up until 4 minutes before the 911 call. So we have this information, and then we also have proof in the record showing that the shooter was wearing distinctive shoes, and my recollection is that the defendant, when he turned himself in, was wearing shoes that matched that description. So I don't think under the standard for Strickland, a reasonable probability that the trial outcome would have been different had the jury not heard that he had a prior conviction for ag assault with a deadly weapon. You have this information. You have the petitioner's own statements. You have the telephonic records connecting him to the victim with threats. And then you have actually video evidence of the shooting. And then you have a video of the shooter and his shoes, and you have the petitioner and the same shoes. This is not a case where a jury would have heard all this information, and then heard, prior aggravated assault with a deadly weapon, even if they did hear, yes, he inflicted injury on someone, I can't remember Mr. Hedrick's phrasing, but he caused injury to another person. Even if the clerk had gone through all of the details, that is not what this case turned on. And the question is whether there's a reasonable probability, whether it undermines confidence in the outcome of the trial, in the verdict, and that is just simply not the case here.
Was a limiting instruction given?
There was not a contemporaneous limiting instruction, and I've looked. The post-conviction appeal record does not include the direct appeal record. I have looked back at the direct appeal record, which we have access to because I handled the direct appeal, and if this court were to take judicial notice of the direct appeal record, I don't think that the jury instructions are included.
Okay.
Let me amend that. There's a written, the paper copy that was admitted for identification, and that does not include a limiting instruction, but we don't have what the trial court actually said. I presume that it would be the same thing, but there's certainly, it would have been helpful if there had been one, but there does not appear to have been a contemporaneous limiting instruction or one in the closing instructions.
So I take your point that the proof is overwhelming, and so that because the proof is overwhelming in part because of statements that the petitioner made to two people, that maybe this one particular fact didn't weigh into the jury's analysis. So I take that point. Does it matter, though, to whom, though, the defendant confessed? So, for example, one of the people the defendant confessed to was another inmate.
Yes.
So typically, at least in my experience, those witnesses are viewed with some skepticism because typically they're receiving some sort of benefit for their testimony. The other one, I don't recall, but I think was a step-niece.
Yes.
I mean, does the fact here that he had, I can't remember Mr. Hedrick's colloquialism, otherwise bodily injured someone else. I mean, the fact that he did that, doesn't that help, I guess, maybe bolster then the credibility of an inmate coming in to say, but he told me?
I don't think so, because I think you have to actually look at what Mr. Dobbins said. This is not what we see sometimes, which is a cellmate saying, oh, he told me he did it, no further details. This is Mr. Dobbins kind of admitted, yes, I am hoping for some beneficial treatment. Favoritism, I believe, is the word that he used. But Mr. Dobbins, what he said is, the defendant told me that he had some sort of disagreement with the victim, kind of some background information. But what's key about Mr. Dobbins is he says, the defendant told me that he shot him once, it didn't work, or something to that effect, and then I shot him again and really got him that time. And that's actually consistent with the video of the shooting, where we have a video of the shooter approaching the victim, shooting him, running away, dropping something, picking it up, and then firing more shots. So it's not simply a matter of Mr. Dobbins saying, oh yeah, he confessed to me. We're chatting and he just revealed to me that he had shot him. Now I would like some favorable treatment. This is detailed information that is consistent with the video evidence that was introduced at trial that the jury was able to see. And I think also we can't ignore the fact that there is the text messages with the threats from the defendant to the victim and the matching footwear. So I don't.
Okay.
And certainly the jury was well aware of Ms. McDowell's somewhat contentious relationship with the defendant.
Sure.
And it was,
step-niece, right?
yes, it was very clear to the jury that Mr. Dobbins was incarcerated and that he wanted some sort of benefit from his testimony. So again, when you look at everything for the deficiency prong, I don't think that the petitioner's met his burden. I think this court could very well find that the petitioner has not offered argument on prejudice, so it's actually waived, and he has to show both prongs. And I think that even this court gets to the prejudice analysis when you look at all of the evidence, not just these individual pieces, we look at all of it in context. The petitioner just cannot meet his burden of showing a reasonable probability the trial outcome would have been different, but for counsel's failure to move for bifurcation. If there are no further questions, the state asks this court to affirm the judgment. Thank you.
Thank you.
Mr. Hedrick, we'll go ahead and give you your full 2 minutes.
Thank you, Your Honor. I rise to urge the court that the prejudice argument, I'd suggest that the prejudice argument is not waived because the brief clearly argues at page 21 and then again at page 23 that this was a previous offense inadmissible under 404 that was presented to the jury, that the jury heard what they should not have heard, and that is the harm, that is the prejudice. And I say that in light of the Strickland standard. When we think about the Strickland standard as 466 U.S. 668 at 687, the Supreme Court phrases the standard as whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. And so in this case, when we're talking about taking the guide rails, the barriers, the guide rails of the adversarial process. So the rules of evidence that say the adversarial process must occur within these rules to make it fair. There are some things that we cannot allow in the process. And we are taking those guide rails away, and we're giving the jury information that our rules of evidence say a jury should not hear. That is an undermining of the adversarial process that cannot be
doesn't translate
permitted.
into Sixth Amendment prejudice though, right? And so I was taken with the argument in the brief, and it occurred to me if you expand it to its logical extent, that every missed call by a trial court on a Rule 404B issue gives rise to a new trial under post-conviction. I mean, inadmissibility of evidence under the rules of evidence doesn't necessarily translate at all into prejudice under Strickland, does it?
I would say not always, but I would say not always, but I would say it's a matter of degree. And I think it has to be analyzed as a matter of degree. I mean, you could conceive of a time where the evidence is so hurtful that it cannot be and so obvious that it cannot be permitted, as opposed to some of the gray areas where we think about, picky hearsay rules or things like that perhaps no. But in a case like this, we're talking about the core question: is this man a killer? They should not be told that, well, he took a deadly weapon to somebody else and really hurt that guy really badly. So for those reasons, and the others in the brief, we urge that the court reverse. Thank you.
Thank you, counsel, thank you.
We appreciate your arguments. The case was well briefed. And before we take our break, there were two people I forgot to thank. One is Vanessa Jackson, because she was hiding over here